Good afternoon and welcome to Quadrant Chambers and our latest aviation panel event. This is one of our programme of similar events that we're offering to the aviation legal community in London and beyond. And I know many of you will have been at our last event on airports a few weeks ago, and we had as our guests Kate Staples, who's the General Counsel of the CAA, and Paul Griffiths, who is the CEO of DXB. We've now decided that the time is right for this event, an aviation litigation workshop. There are a raft of changes to the procedural and evidential rules underway, particularly in the property and business courts of the Queen's Bench Division, including the Com Court, where we spend most of our time. Changes to the rules on witness statements, management of disclosure, privilege, and because of Brexit, the foreign jurisdiction rules all require attention. So I'm extremely pleased to be introducing four of my colleagues in Chambers who will be giving you, I hope, a concise and precise overview of the latest developments and perhaps the occasional insight of their own. Before we begin, a couple of practical matters. As usual, in this version of the Zoom platform, to manage bad bandwidth, I'm afraid only the speakers can use their cameras and microphones. Nevertheless, we do welcome questions, which I intend to take at the end. And for that purpose, please use the Q&A dialogue in Zoom rather than the general chat function. And please put your questions at any time during the talks, and I will take them at the end. So, giving our first talk about the new regime regulating witness statements in the business and property courts, I'm delighted to introduce John Kimbell QC. John, as you know, appears high in all the directory rankings for silks in aviation, and his recent cases include the Egypt Air Flight 804, Air France Flight 447, and of course the Malaysian MH17, which was shot down, and the Shoreham Air Show crash. We can also mention, perhaps in a way that he cannot, his robust involvement as the judge in the 2020 aircraft leasing case, Cathay Pacific Airways against Lufthansa. I'm particularly glad to have John speaking today because he is a member of the Witness Evidence Working Group, which recommended the changes. Thank you, John.
Thanks very much, Matthew. So you've got that 12 minutes whirlwind tour of the new rules in the property and business courts. Starting with some basics first. PD 57AC, attractively named as they all seem to be these days, imposes new stringent requirements on the form and content of witness statements for trial. The aim of the practice direction is for witness statements to be much shorter and much more selective as to what they address and much more transparent than they tend to be at present. The practice direction itself comes into force in only about 6 weeks' time on the 6th of April, and that is without any transitional measures. And it will apply immediately on that day for any witness statement signed on or after the 6th of April. Just to be clear, it's not a pilot, and it's not an opt-in provision either. It's mandatory and in full effect in the business and property courts from the 6th of April. It applies to all witness statements for use in trial, whether it's a Part 7 or Part 8 claim, and applies nationwide in the business and property courts. That includes the shorter trial scheme, the short and flexible trial scheme, as well as the ordinary Chancery Division Com Court. There are some specialist proceedings which have been excluded. Anyone interested can look at those in practice direction paragraph 1.3, but they mainly relate to insolvency. Now, it doesn't apply to any interlocutory applications, and it does not apply to any claim in the Queen's Bench Division, which is not in the business and property courts. So that's the basics. What's the background? Why is there a change being introduced in the first place? Well, Some of you may not remember, witness statements were introduced in 1986, and the idea then was to save time and promote settlement. It was part of a sort of cards on the table approach. Before the idea of witness statements was ever introduced, of course, what had to happen is that witnesses had to be examined in chief, much as they are today in the Crown Court. When they were introduced, they raised pretty quickly, actually, cost concerns, because it was clear to everyone involved that whatever savings were made in terms of shortening time at trial for old-fashioned examination in chief, they were more than wiped out by the cost of preparing witness statements. Same complaint was made to Rupert Jackson in 2005, but in the event, although various suggestions were made as to how the rules could be changed and modified, in fact, nothing didn't get changed at that time. So by 2018, it was the commercial court, it was the judges of the commercial court who took the initiative and decided that it would be a good idea to set up a working group. And that working group comprised judges, barristers, solicitors, and some arbitrators, and as well as some representatives from commerce. Now, the working group carried out an online survey in late 2018, quite a few responses, nearly 1,000, and the consensus that came back, having asked everyone that we could think to ask what they thought of witness statements, what came back was that they were overlong, over-lawyered, overfull of comments and references to documents, and what was happening was that actual witness recollection was being lost in the process of overdrafting, as it was perceived to be. And 80% of those who responded, which is an extraordinarily high figure, supported tougher enforcement of the current rules. And you'll see a reference there to the final report that was published in 2019. So what were the recommendations? Well, there were 4. First of all, there ought to be a statement of best practice, the BPS as I'll call it, on how to prepare witness statements. Secondly, that there ought to be an enhanced statement of truth for the witness to confirm his or her understanding of the statement of best practice. And this is one that you're probably most interested in. So the solicitor or legal representative for represented parties ought to sign a certificate of compliance. So it's not a statement of truth, but it's a certificate of compliance, certifying that as far as that a person is concerned, the practice direction and the statement of best practice had indeed been complied with. Fourthly, there was a proposal to give consideration to a new pre-trial statement of facts, a sort of, for those of you that do arbitration, a sort of memorial just before the hearing to set out how it is that the party said it was going to prove its case on the documents. And the reason for considering that was that if a narrative and commentary on documents is all going to be removed from the witness statement, where are you supposed to set out your case? Often it's done these days, as we all know, through the lead witness's witness statement. But as you'll see, as I go on, in fact, that 4th point wasn't pursued and hasn't found its way into the new practice direction, but the first 3 points have found their way in. So what are the new rules? Paragraph 3.1 of the practice direction is the core provision. And what it says, I've added here emphasis, you'll see in bold, which isn't there in the rule itself. 3.1 says witness statement must only contain, first of all, evidence as to matters of fact that need to be proved by the evidence of the witnesses in relation to issues of fact. What does need? How do you know what needs to be proved? Well, the answer is look in the pleadings. But in particular, now it is said expressly that something does not need to be proved if a witness can add nothing to a disclosed contemporaneous document, or indeed if it's common ground. So there's a very strong steer away from the narrative, long narrative witness statement, which tells the story. It is no longer appropriate, or indeed it's contrary to the rules to tell the story, as it were, in the witness statement by referring to lots of documents. You only use the witness statement to prove those things that can only be proved by oral evidence. So that's the first point. The second point is, and this is a rather strange formulation which takes some time to get your head around, a witness statement can only contain the evidence, you read it for yourselves, 3.1, much past, witness statements, it was not possible to give evidence in chief by way of a witness statement. And that, of course, harks back to the practice in the civil courts before 1986, i.e. before witness statements were even introduced. So that's the core provision of 3.1. The next key part of the new rules is the statement of best practice. And the key points here are that the witness statement should be based on an interview, i.e. an old-fashioned proof of evidence, and that should be created without the use of leading questions. The interview should be recorded in some form or other, whether by notes or ideally recorded with audio-visual equipment. It's still the case under the new rules that a solicitor or legal representative can assist with, as they do now, structure, layout, and scope of witness statement. And indeed, it's still possible under these rules for the legal representative to draft the witness statement. But the heavy qualification here is that the content of the witness statement must not go beyond the interview record that I've just referred to. A change is that the witness must state how well they remember matters addressed. And that is, well, it doesn't say exactly, it's quite clear that what that means is without having any memory refreshing through documents initially. Just first of all, what do you remember of the meeting, the day in question, without having refreshed your memory? Of course, once you've done the first interview, you can use documents to refresh memory, and this is the transparency element. First of all, as a condition, you could only do that if the witness, him or herself, created or saw the document at the relevant time, and all of those documents should be identified in the witness statement. So what you can't do is, behind the scenes, refresh a witness's memory without disclosing the means by which you have done that. Paragraph 3.8 of the best practice guide says that as few drafts as possible should exist between the proof of evidence, the first interview, and the final witness statement. And much as is said already in all of the guides, no commentary on other evidence, no narrative based on documents, and no argument. So the enhanced statement of truth, there it is in all its glory. The bits highlighted in red are the things that the witness, him or herself, has to acknowledge and state that he or she understands it's not his or her function to argue the case and not the function to take the court through the documents. So if you produce a witness statement which does either of those things, you are already, as a witness, in breach of your statement of truth, which is quite obviously, as you all know, quite a serious matter. And then you can see here in the second paragraph, on the points I understand to be important in the case, I have stated honestly how well I recall matters and whether my memory has been refreshed by considering documents, and if so, how and when. So this is another example of the transparency element that I referred to right at the beginning. It's a bit like what's happening is that whereas now we have witness statements which are produced and polished, arrive like a smooth running luxury car, here the rules require you to look under the bonnet and disclose how you got there. This is the solicitor's certificate of compliance, slightly different terms. You see the definition of relevant legal representative. It will all depend on the nature of the firm and the size of the firm, but broadly speaking, in most cases, the expectation is that it will be the senior lawyer with conduct of the case. But you'll see it's a certificate that requires you as a solicitor or legal representative to say that you're satisfied that the rules have been complied with and that the statement of best practice has been complied with. So again, it's looking behind the scenes what would ordinarily be absolutely privileged and going on behind the scenes without anyone knowing. That you have to now come out in the open and say, we have complied with the statement of best practice in the production of this witness statement. Sanctions. What happens if you don't comply? Well, the answer is that, as you'll see there, first of all, all of the other case management functions and powers that the court has remain, but there are four that are specifically mentioned. One is that you'll lose the permission or your witness statement will be struck out. And that is likely to happen, if it happens at all, at the pre-trial review. So part of the changes that are going to be introduced, I think, practically, is that the pre-trial review in business and property court cases is going to become more important, and the judge will be very keen to look at the witness statements at that hearing. Secondly, there might be an order, and this could be as late as the PTR, that any defaulting trial witness statement has to be redrafted in accordance with the practice direction. There might be a cost order, or that will be after the event. But really it's number 4 that is, I think for most advocates anyway, the nightmare scenario. You've managed to get through the PTR, no one has noticed that your witness statement is non-compliant, the judge doesn't like it and says, right, in that case, I'm going to order that you examine this witness in chief. Now that is a nightmare scenario because most of us, certainly I'd include myself, haven't examined a witness in chief in a civil court ever. And you wouldn't want to be doing it on the first day of a 10-day commercial court trial. So those are the sanctions, and that's really they're intended to try and encourage people to comply with the rules in the first place. Finally, some good news. You might be somewhat depressed by now. There is the possibility to apply for dispensation, and it may be that in the early days this is used in order to soften the impact of the rules in the early during a sort of settling in period. Interestingly, the application for permission to vary or depart from either the certification by the legal representative or the statement of truth by the witness is ordinarily generally to be made without notice and without a hearing. So it's the sort of thing that happens on paper. There's some guidance that's been given very recently by the Admiralty Judge in the context of maritime claims, because it's realised that obviously in this applies equally to the aviation context. In the context of an accident, there will be people that sign documents which are very close to witness statements, and it may be that compliance with PD 57AC won't be possible for those witnesses, and that is a possible reason for disapplying the full rules. There you are. My time is up. I'm sorry it was such a whirlwind tour, but I'm very happy to take questions at the end. Thank you.
Thank you to John. I think we can all imagine some of the fundamental shifts in thinking that that's going to require, and some of you may have questions on what impact the change of rules is going to have at trial. If you have any such questions, please add them in to the Q&A dialogue. Thank you, John. Secondly, the second person to give a talk this afternoon is Mark Stiggelbout, who's going to tell you about the latest developments in the disclosure pilot in the BPC. I would say that Mark has now moved successfully beyond the up-and-coming category of aviation barristers and is now definitely in the arrivals hall. He has an expanding back catalogue of airline and tour operator liability cases, some of which you will know, Horsting and Snap and Marchbank Smith. I'm delighted that he's able to tell us something now about where we are in relation to disclosure. Thank you, Mark.
Thanks, Matthew. Good afternoon, everyone. I'm going to be talking about the disclosure pilot scheme and giving an update both on the rules that will be changing in April of this year and also some of the possible future changes beyond that in light of the ongoing review. Now, as we probably all know, the disclosure pilot has been in operation in the business and property courts for 2 full years now, and that was the original intended duration of the pilot scheme. However, it's now been extended for a 3rd year to the end of this year, 2021, and the current indications are that it is likely to remain, at least in some form, after that 3rd year. The intention of the pilot scheme was always that it would be a living one, monitored by the Disclosure Working Group under Professor Rachel Moore-Heron of Queen Mary University, and importantly, responding to user feedback. And in light of that, a series of changes will take effect from this 6th of April. And the Disclosure Working Group is also considering further possible changes to try and enhance its operation. Before turning to those changes, here's a slide which should be familiar to many of you. The pilot was said to be intended to effect a cultural change, not simply to rewrite the rules of disclosure in Part 31 of the CPR, but to be driven by reasonableness and proportionality and specifically targeted to issues for disclosure. So as we all know, that means we have now initial disclosure with the statements of case, extended disclosure, disclosure models A to E, and a push to try and get the parties to use Model C where possible, so the requests, by saying that Model D should only be used where Model C is not sufficient, and we're told that Model E is only appropriate for an exceptional case. We're all now familiar with the list of issues for disclosure that has to be prepared, and that's been stressed not to be simply the list of issues that you have for trial, generated by every denial or non-admission, but key issues which need to be determined with some reference to contemporaneous documents. And finally, we've got the disclosure review document that we've all grown to love, by which we're invited to identify, discuss, and seek to agree the scope of any Model C to E extended disclosure. So what are the changes that will be coming into force this 6th of April? Now, largely these are clarifying ambiguities and inconsistencies in the pilot itself, but there are a few substantive changes in there. So first of all, there's a change to initial disclosure, or at least a clarification, because some of the feedback from users was that it wasn't clear whether the parties could only agree to dispense with the initial disclosure itself, or whether they could also agree to dispense with initial disclosure lists. And it's now been clarified that you can just dispense with both by agreement. In relation to known adverse documents, the April changes will clarify that the latest time for these being disclosed is at the time ordered for extended disclosure, or 60 days thereafter in a Model A case. And apparently there'd been some feedback that people were not sure when this duty applied. Some people thought they had to disclose known adverse documents as early as the commencement of proceedings or with the initial disclosure, but that's been clarified not to be the case. There is then a substantive change in relation to the duty to preserve documents. And the change will be that the duty to contact relevant employees will be limited to where there are reasonable grounds for believing that the employee or former employee may be in possession of disclosable documents which are not also in the party's possession. This change responds to feedback from users that the duty was both too onerous in the sense that it could be hard for the client to track down former employees, particularly when they might not have relevant documents, and also that it was alarming and irritating for these employees, for former employees, to suddenly receive this notice out of the blue. So the duty has been brought more into line with the other duty, which was in the pilot scheme to begin with and remains, that you only have to take reasonable steps to contact agents and third parties. The fourth change that I've got on the slide is hidden in the definitions section. The meaning of list of documents has now been amended so that it doesn't now include how the information is held. It used to be that your initial disclosure and your extended disclosure list of documents had to say for each document whether it was held in emails or on a voicemail, for example. So that's now been changed. One of the themes of the changes that are coming into force in April is an attempt to make much more clear the distinction between Model A and B extended disclosure on the one hand, and on the other hand, Model C to E extended disclosure, which are all search-based. So the changes clarify that you only need to write to your opponents within 28 days of the final statement of case if you're intending to seek extended disclosure, which includes Model C to E. So you don't have to if you're just going to agree Model A and B for everything. And similarly, there's a clarification that you don't need to prepare the list of issues for disclosure if the parties have agreed Model A and or B for all of the issues for disclosure. Now, the disclosure review document itself is subject to a few changes. There's a clarification that this doesn't need to be completed if there is going to be no search-based extended disclosure. So if you've just got Model A and B extended disclosure, that is. There's also an addition to paragraph 10.2, which says that in cases where there is likely to be limited disclosure or the identification and retrieval of documents is straightforward, not every section of the disclosure review document will need to be completed. Now, the paragraph 10.2 that was in the original pilot scheme had said that for complicated cases, you could amend the disclosure review document to make it work better, but it didn't say anything about the more straightforward cases. So this addition to paragraph 10.2 is intended to make it a bit more simple to use the pilot scheme in the more straightforward type of case. And finally, on the DRD itself, there'll be a new pro forma or an updated version of the pro forma with some of the questions changed to make it a little bit more user-friendly. And finally, in terms of the 6th of April changes, there is a change in relation to disclosure guidance hearings. The pilot scheme as it stands now says that the parties can seek a disclosure guidance hearing for issues as to the scope of extended disclosure. But there's now been a clear attempt to try and make it wider so the parties can ask for the court's guidance on any issue as to the pilot's operation. And in addition to that point, there's a new sentence saying that the court is able to give guidance on the documents and not just at a hearing. And that was probably implicit anyway, but it's just responded to some feedback from users that they may have thought guidance would be useful in a few cases, but often when they didn't think a full hearing was warranted. Now, in terms of ongoing review, the Disclosure Working Group has produced a very long third report setting out various forms of feedback they've received from practitioners and given a few things which they think are working overall in a satisfactory way. The first is it's thought that it's useful that the pilot scheme is a one-stop shop now. Instead of having disclosure rules in different places in the CPR, you now know exactly where to go for your disclosure issues. Secondly, it's thought to be useful both for the parties and their legal representatives to have the principles and the disclosure duties clearly specified. Thirdly, the Disclosure Working Group has said that initial disclosure is now thought to be useful, although they themselves point out that it was not well received initially. And if you do look at the reports produced by the Disclosure Working Group, there's certainly a lot of negative feedback about initial disclosure and how it front loads costs and can impede settlement, particularly in lower value claims. And fourthly, the Disclosure Working Group thinks that the idea of disclosure models, at least taken in isolation, is a useful replacement for having a list of alternative orders for disclosure that we have in CPR 31.5 subparagraph 7. Having said all that, the Disclosure Working Group has also identified points that need further consideration and which will be subject to ongoing review and further feedback from users. The first of these is in relation to lower value claims, namely that the pilot is thought to be too complicated for these and more costly than Part 31. So, for example, if you have an aircraft redelivery dispute under a lease, you might have 8,000 to 10,000 pages worth of documents. And under the pilot scheme, you have to review those and judge them against a list of issues for disclosure and possibly also a number of specific requests under Model C from the other side. And that can be a time-consuming and costly process. And many people would think that it would be better in that kind of case just to be able to disclose all of the 10,000 documents rather than go through this difficult process. Secondly, Model C requests have been said by many to create an additional workload and impede an efficient review of data, particularly if used too extensively. So they're thinking of ways to try and encourage parties to use Model C requests less extensively than they have been. Thirdly, a number of users fed back that narrative documents created a problem because in Model D, you have the ability to have Model D disclosure with or without narrative documents and a presumption not to disclose narrative documents. And this creates additional work for those doing the review, with it often being very difficult to identify what is and what is not a narrative document. And lots of people have fed back that it would be much more straightforward and probably a lot cheaper if you could just disclose all your documents, including narrative documents, without having to try and sift that difficult category out. Fourthly, lists of issues for disclosure. These have been said by many users to be difficult to define and agree, and in some cases to duplicate the effort in agreeing the list of issues for trial at the CMC stage. And a particular issue is that parties are often wary to give anything up at so early a stage in the litigation that trying to agree the list of issues for disclosure becomes something tactical and very difficult to reach agreement on. Fifthly, the issue of matching issues for disclosure to multiple models can be very complex and costly, particularly as we know you can have different models for different issues for disclosure, and even different models for different parties on the same issue for disclosure. And finally, in multi-party cases, there's wide recognition that the pilot doesn't operate effectively at all. And I've certainly experienced this. When you have to deal with a case with 3 or more parties, you'll see that the scheme just hasn't been designed for that. And the documents you have to use, the pro forma documents, just don't work very well. So these are all points which the Disclosure Working Group is still thinking about solutions for, and are still welcoming feedback from users. So if you have any particular gripes, do please send your feedback to the Disclosure Working Group this year. And that's all I have to say on the disclosure pilot, as my time is up, and I'll hand back over to Matthew.
I'm now going to turn to our third speaker, Tim Marland. He will be speaking about the rapidly changing position as to foreign jurisdiction. I'm sorry to say that it gives him the joyous excuse to discuss his and mine most recent outing against each other in the commercial court about anchor defendants, in which he beat me. Tim, as you all know, is one of the most senior and prominent aviation barristers, and in the very top rank in the directories. And I can say this, if you've not heard of Tim, you are not in aviation. Thank you, Tim.
Right, obviously we're dealing here with jurisdiction after Brexit. The position we found ourselves in beforehand was, of course, that we had the joys of Brussels recast and Lugano, which of course to all intents and purposes was the same. Those regulations, conventions, as we all recall, strove for certainty over flexibility, and whilst sometimes one found oneself on the wrong side of a hard rule, generally speaking, we all knew where we stood. Those are both now gone. As you're all no doubt aware, we are attempting to bring ourselves back within Lugano, but it hasn't happened yet. So are they still relevant? Well, yes, unsurprisingly, you might think transitional cases, that is cases that were started before the 31st of December, Brussels or Lugano, as the case may be, will still apply. Many of you will have experienced or indeed been involved in the rush to issue proceedings where one wished to take advantage of Brussels or Lugano before the 31st of December, and we're still seeing some of those filtering through. Second aspect of relevance for your UK domiciled clients in particular is that obviously they will still continue to apply when people are seeking to drag your client into a member state. And the Brussels and by extension Lugano deal with litigants, defendants who are domiciled in third countries, and effectively, although it's perhaps not as simple as that, apply the domestic rules of private international law in most cases. The obvious area which is still of relevance, because it features large in what we do, is Article 25, which of course is the jurisdiction agreements provision, which, as we know, if the parties have agreed that a court of a member states to have jurisdiction, and that agreement is in writing, etc., that will take precedence. And that, as we can see from the clear words of Article 25, applies regardless of the party's domicile. So it will catch non-member state domiciled defendants just as much as member state ones. One difference that we now find ourselves in is, of course, the area of lease pendens. Under the old position, if there were parallel proceedings, again, an aspect of Brussels that we're probably all familiar with, one had, first of all, the application of the rule where the court first seized basically takes jurisdiction, and that any other court of any other member state had to stay its own proceedings until such time as the court first seized said, yes, we have jurisdiction. When that court did that, then the courts of other member states had to decline jurisdiction, whether they wanted to or not. The position when it's a toss-up in parallel proceedings between a member state and a third country, such as we now are, is of course different. First of all, the stay is discretionary, not mandatory. So the court of the member state may stay proceedings if, and you'll see the conditions that are met there, it's expected that the court of the third state will give a judgment capable of recognition and, where applicable, of enforcement within the member state. And wonderfully nebulous words, given that the regulation strives for certainty, the court of the member state is satisfied that a stay is necessary for the proper administration of justice. There are also criteria whereby the member state may continue the proceedings in front of it at any time. First, perhaps less controversially, if the proceedings in the third state are stayed or discontinued. Secondly, if it appears that the proceedings in the court of the third state are unlikely to be concluded in a reasonable time. Now, that shouldn't be a factor in terms of litigation in this country, but one never knows. And thirdly, of course, those weasel words again, the continuation of the proceedings is required for the proper administration of justice. So what we have lost in losing Brussels is the fact that member states where there are parallel proceedings are, of course, no longer obliged, as they were previously, to give way if we were the court first seized, and it's all now a question of discretion. There's also the issue of what's known as the Italian Torpedo. Some of you, I'm sure many of you will be familiar with this. One of the reasons that Brussels was recast was to disarm the Italian Torpedo. In brief, this was where people were circumventing exclusive jurisdiction clauses by rushing off to a jurisdiction such as Italy, so that was the court first seized, and then relying on the fact that it would take that court forever and a day to determine its own jurisdiction, by gumming everything up. Article 31 of Brussels removed that threat because it was for the court where the jurisdiction agreement founded jurisdiction to decide its own jurisdiction. But Article 31.2, the relevant provision, says, without prejudice to Article 26, where a court of a member state on which an agreement referred to in Article 25 confers exclusive jurisdiction is seized, any court of another member state shall stay proceedings. Of course, we are now in the position where an English court is not a court of a member state, and so this does not apply. However, all is not lost, because we do have one of the few agreements we've seemed to have held on to through this is the Hague Convention on Choice of Court Agreements, which, as the name suggests, is an international convention dealing with exclusive choice of court agreements. It doesn't deal with non-exclusive ones, but it deals with exclusive ones, in civil and commercial matters and describes the international element in Article 1. It's not a complete overlap, of course. First of all, Hague Convention only applies to agreements concluded after the 1st of October 2015. Of course, not disputes which have arisen since then, but agreements concluded thereafter. It doesn't apply to consumer contracts, doesn't apply to carriage of passengers and goods, doesn't apply to claims for personal injury, although one wonders why an exclusive jurisdiction clause provision would do. Doesn't apply to arbitration. There, at least, it bears some similarity to Brussels. The EU, in ratifying it, did also carve out certain insurance contracts. It didn't, however, carve out reinsurance, aircraft insurance, liability from use of aircraft, financial loss associated with aircraft, any risk or interest connected with the above, or any other what I might call large risks, which are the ones you see at the bottom there. So in general, the sort of insurance contracts that you deal with should still be caught, but you need to be aware that there are some which are carved out. So where does that leave us? Well, it leaves us basically as though the member states of the EU were another country. Suing someone in France is the same as suing someone in Nigeria. We're back in the good old Practice Direction 6B, and essentially one has to go through all the process that one would one had to previously for non-EU countries, establishing a jurisdictional gateway, the good arguable case, the necessary and proper persons, all of those matters. So to that extent, it's the same. Now, there is one saving, which is that consumer and employment contracts are basically carved out of this arrangement, and they are in effect treated as though Brussels still existed. So there are there's provisions have been added to Section 15 of the 1982 Act, which, again, broadly speaking, reflect the Brussels position in respect of consumers and employees, including, importantly for our purposes, the carve out for contracts of transport which are not packages. So consumer contracts, which are contracts of transport, are not caught by the special consumer provisions. And just finally, again, as one would expect, given that these are intended to mirror Brussels, it is expressly part of the changes to the 82 Act that those provisions are to be interpreted with regard to CJU case law and with regard to the various reports that have been produced on Brussels and its predecessors. And that is me done, you'll be glad to hear.
Thank you, Tim, very much. A very clear overview of where we are now. I suspect there are a number of questions about what sort of new areas of litigation this new regime is going to create. If you have any questions about that, please add them to the Q&A dialogue. Lastly, I'm delighted to introduce Simon Oakes. It's fair to say that Simon is one of our promising newcomers and is developing a very substantial presence in aviation on the back of an already established commercial practice and a considerable experience of very high value personal injury cases. Simon will speak on the recent Jet 2 case and its implications for the law of privilege. Thank you, Simon.
Thank you very much, Matthew, and good afternoon, everybody. Yes, this is CAA and Jet 2, a very significant case of last year, which some of you would be familiar with already, particularly those attending from the CAA and Norton Rose. Thank you especially for joining us. So I'm going to be talking about this case, which recaps at significant length some of the important features of legal advice privilege and narrows slightly the scope of what is caught by legal advice privilege. And if we have time at the end, I'll give you just a very quick update on the Sports Direct case and its recent consideration by the Court of Appeal on the Supreme Court's refusal of permission to appeal again. So this is a case about legal advice privilege, and as you all remember, privilege divides into litigation privilege, concerned with communications which came into existence for the purposes of pursuing or defending actual or proposed litigation, and legal advice privilege, that is, confidential communications between a lawyer and his client made for the purposes of giving or obtaining legal advice. And that's the important part of this case, the made for the purposes of giving or obtaining legal advice, whether or not there were existing or contemplated proceedings. Now, the facts of this case, very much in brief, the case arose in the beginning out of the refusal of Jet2 to participate in the CAA's ADR scheme. Jet2 only wanted to participate in the existing PAC scheme. And so in December 2017, the CAA put out a press release criticising Jet2's refusal to enter into the new ADR scheme. Jet2 thought that this was misleading and unfair, and it wrote to the CAA complaining about the press release, and it published its letter on its own website. The CAA responded on the 1st of February 2018, continuing to criticise Jet2's stance, and that correspondence found its way into the Daily Mail, who published it under the headline, "In leaked letter, Jet2 boss reveals why it won't join new flight delay compensation scheme. Too many customers will win their money back." So that was the exchange of correspondence. But before the CAA responded on the 1st of February 2018, it had internally considered what to do. And in particular, there was this email, which is on your screen now, about developing a narrative around Jet2 and referring to the potential response that could be made. And you'll see the reference to attack dogs, a particularly vicious example of which now appears on your screen. On the 24th of January, so that was email number 1, 18th of January. On the 24th of January, a first draft of the letter was circulated, and importantly, it was addressed to a mixture of managers and directors, and also a CAA legal advisor. And in the draft, the author, rowing back from the attack dog reference in the previous email, said that it was perhaps more of a cranky alpaca, perhaps one a bit like this. And I commend the entire video to you on YouTube. It really is a gem. In other words, the case concerned emails which were addressed to lawyers seeking legal advice, but also to non-lawyers seeking non-legal input. And that's a scenario that I'm sure we've all encountered in practice. Jet2 ultimately brought judicial review proceedings challenging the lawfulness of the CAA's decision to issue its press release and publish the correspondence. And one of the grounds, the important one for the purpose today, was a contention that the CAA had acted for unauthorised purposes, that essentially it had set out to deliberately damage Jet2's trading interests and reputation by singling it out for severe criticism. And so one of the things that Jet2 sought in those JR proceedings was disclosure of all of the drafts of the February 2018 letter and all records of any discussions about those drafts, in essence to find out whether the attack dog reference had flowed throughout the draft and had motivated the Jet2 approach, or whether it was more like the email that had been voluntarily released by the CAA, the cranky alpaca. That was, in essence, with apologies to the parties who were involved and can explain in much greater detail what exactly happened with more time. That's the setup. There was a dispute back and forth at first instance, and I won't take you through that given the time constraints. But in the Court of Appeal, with the leading judgment delivered by Lord Justice Higginbotham, did two things. He recapped some of the most important law on legal advice privilege, and then set out some propositions of his own applied to the facts of this case. The propositions are set out in the judgment in some detail, and I won't go through them in minutiae, but they are worth a read to remind yourself of how legal advice privilege works. There's the basic test that I outlined earlier of a communication between a client and lawyer, or a lawyer and a client, made in confidence and for the purpose of giving or obtaining legal advice. In-house lawyers are covered as lawyers for the purposes of this kind of communication. And once the advice is given, if it's passed on, considered, or applied within an organisation, that recirculation of the advice is still caught by legal advice privilege. It's a bit like an ISA. Once you're into the advice has been delivered, recirculation of it is still within the protective wrapper of legal advice privilege. There is a wrinkle, the employee-client rule, as discussed in the Three Rivers number 5 case. And this is the idea that certain employees won't count as the client for the purposes of a communication between a lawyer and a client, that employees, like agents, have to be particular people who are tasked with seeking and receiving such advice on behalf of the client, the sort of thing that you might want to draft in your retainer letter if you want to make clear which employees are going to be caught within privilege and which ones are going to be outside. And again, this is paragraph 56 of the judgment, the Court of Appeal criticised this element of Three Rivers number 5, agreeing that the rule works pretty well for small companies and individuals, but very badly for large corporations, where individuals who might be close to the detail of the facts are, and therefore able to communicate with lawyers easily, are not the people who are specifically tasked with seeking legal advice and so forth without privilege. There's a further criticism of Three Rivers, but the Court of Appeal felt squarely bound by it once more. And there is some helpful discussion about the scope of legal advice. That you remember that the communication must be for the purpose of giving or obtaining legal advice. And so the Court of Appeal restated that legal advice includes advice on the application of law in practice, including consideration of particular circumstances from a legal point of view. And that, of course, includes not merely communications which expressly seek to give or receive legal advice, but also what's called the continuum of communications between a lawyer and a client, aiming at keeping both informed so that the lawyer can advise when required. And so legal advice is broadly defined. So those were the propositions that the Court of Appeal recapped, the most important ones. Specifically as applied to this case, the Court of Appeal was considering the situation of a communication which is not just for the purposes of obtaining legal advice, but also for other things. The kind of email which is sent to multiple addressees, one of whom may be a lawyer who's asked for legal advice, but also other people who are asked to comment on non-legal aspects. And so what does one do if the communication has more than one purpose? Is it enough if one purpose of the communication is to obtain legal advice privilege? And for litigation privilege, the answer is no, that in litigation privilege, the dominant purpose of the communication has to be for pursuing or defending the litigation. But it was unclear until this judgment whether that applied to legal advice privilege. And the Court of Appeal quite simply said that it does have to be the same. It overruled the obiter view given in SFO and ENRC 2018 decision of the Court of Appeal, and said that the dominant purpose rule now applies to both litigation privilege and legal advice privilege. It brings them both into line and brings legal advice privilege into line with other Commonwealth countries. So in order to claim for legal advice privilege, the party claiming the privilege does need to show that the relevant document or communication was created or sent for the dominant purpose of giving or obtaining legal advice. So if you've got a document or a meeting where the dominant purpose of it is to give legal advice, that's fine, it'll be privileged. But if the dominant purpose of your meeting is commercial, then you can't cloak the whole document of privilege because a lawyer's copied in or is in attendance. And of course, in either type of document, if the non-privileged part can be severed, it's not inextricably intermingled, then the privileged part can simply be redacted and the rest disclosed. So legal advice privilege is now caught by the dominant purpose test that also applied to litigation privilege. What about multi-addressee emails? The Court of Appeal specifically commented on that and said that in the case where, like this one, where you've got emails sent to multiple recipients, some lawyers, some not lawyers, there are two ways of claiming privilege. One is this dominant purpose test that we just discussed, that even though there might be multiple recipients, if your dominant purpose is to seek legal advice, it's privileged. But also if the email might realistically disclose the nature of the advice being sought. And so it's clear from this that in a case where you do have multiple addressees, one does have to be a bit careful, that it is easy when you're sending emails to multiple people to have multiple purposes to the email. And so it may be harder to ensure that your email is privileged. And at paragraph 93, Lord Justice Higginbotham squarely addresses his mind to this and says, well, yes, you have to be careful. He says in terms, legal advice privilege is, ho-ho, a privilege. And those who wish to take advantage of it should be expected to take proper care when they do so. So there is a danger that when sending multi-address emails, privilege could be unavailable because the dominant purpose test isn't satisfied. So you may want to build in a process whereby dedicated emails are sent to the legal team, or you put in a subject line that refers to the legal purpose of sending the email. But this is only a minor clarification and restriction of the applicability of legal advice privilege, because remember that legal advice privilege is broadly drawn. It includes advice given by a lawyer in a commercial context. It includes the continuum of communication that we discussed already. So there's a lot of stuff that's going to be caught by this. A lawyer's response to a multi-addressee email is in any event likely to be privileged, and there is the other limb of ensuring that the communication doesn't disclose the nature of the advice sought or given, further layer of protection. Very quickly, because I know that time is now short, obiter towards the end of the judgment, the Court of Appeal also dealt with collateral waiver. This is the idea that where you voluntarily disclose an email, like the alpaca email, one has to ensure that that voluntary disclosure isn't partial or selective, that it's not cherry picking, giving a misleading impression of the overall communication. And as to that, the Court of Appeal have expressly endorsed the approach taken by Mr. Justice Mann in the Fulham Leisure Holdings case, which I've put on the screen, where Mr. Justice Mann said you look at the transaction to which the disclosure is being made. That's the key. You have to identify the transaction. It's a rather artificial word, but what it is in essence that the waiving party is seeking to disclose. For example, advice given by a lawyer on a particular occasion, and then see whether only part of the material relevant to that transaction has been disclosed, or whether fairness requires the whole of it to be disclosed. And helpfully, the Court of Appeal specifically endorsed the purpose test that Mr. Justice Mann referred to, that one way of helping to identify the transaction is to look at what the purpose of the voluntary disclosure is. Why is it that the party is voluntarily disclosing it? I said that I would say something very briefly about Sports Direct, and it's simply this, that in Jet 2, the court also considered what happens with email attachments. And basically, if you've got an original email that is privileged, it doesn't necessarily mean that attachments to that email are also privileged. Advice privilege covers communication brought into being for the purpose of seeking or obtaining legal advice. So your email can be brought into existence for that purpose. But if you attach a document to that, which is a pre-existing document, which was not itself created for the purposes of seeking legal advice, the mere fact of attaching it to the legal advice email will not cloak it in privilege, nor the rather subtle argument attempted in the Court of Appeal and Sports Direct, can you cloak it by saying that it is that you are seeking, that what is privilege is the fact of the attachment being communicated to the lawyers. That doesn't work either. And the Supreme Court have in the last month refused permission to appeal on this. So we can be reasonably confident that it's now the last word on attachments to privilege emails. So that has been something of a race. And I'm sorry to have taken you right to the wire at 3 o'clock, but thank you very much. I'll now hand back to Matthew.
Thank you very much. I think that is probably the most clear exposition of the Jet 2 case that I've yet heard. And I think it added a colourful glimpse of the moods of alpacas and dogs. Now is the time for any questions. We already have a couple which are directed to John. John, one of those questions relates to what secondary arguments or satellite litigation can we expect as a result of the change in the rules? And I'd like to add my own question to that. Do you expect that there will now be time spent at trial cross-examining witnesses on the process by which their witness statements were created?
Right, well, there are two questions there. I think the answer to both of them is yes. In some ways, I suspect the actual amount of time spent cross-examining witnesses as to how it came about that their witness statement contained X or Y may well go down if the rules are followed very closely, because if the best guidance practice is followed, then every single document that a witness has been referred to refresh his or her memory will be there in the witness statement. But there will be occasions, I'm sure, when a cross-examiner will get a sense that something's not quite right with this witness statement, and that other documents have been seen, and that the person really can't have remembered in as much detail as they claim. But that's the position today. So there may be that sort of cross-examination. But Dan Zoffin's question about satellite litigation, yes, I can see that there is a potential for that, for sure. What is almost guaranteed is that there will be contested applications at the PTR stage. So, and there's a slight difference in approach between the Chancery Division here and the Commercial Court. There's been a bit of a practice in the Commercial Court to avoid PTRs, to let them go through on the nod, sensible parties agreeing directions, no need to have the parties come in. I suspect in the short term what will happen, whereas in the Chancery Division, it's almost always the case that there was a proper PTR. It's a 2-hour proper session. Where are we going? Let's look at the draft trial timetable. I suspect that what will happen is there'll be more of that now. And that's the stage at which there'll be the sniping and the accusations about failure to follow the new practice direction. And if that's made out, then there will be sanctions applied, that's for sure. Not least because, as I said, I think in the talk, this has all come from the judges. This is not from the Ministry of Justice about saving money. This has basically come from the judges. They got fed up with the long witness statements that they just didn't feel corresponded to what the witness actually remembered.
Well, thank you, John. In relation to that, I mean, one of the interesting things about the proposals, and indeed your talk, is the suggestion that a recording should be made of the original interview for the purposes of taking the witness statement. There is, of course, the question of privilege. And I've got two questions arising out of that. First of all, is it part of the expectation that that recording will be kept after the witness statement has been prepared and served? And if so, what use do you see being made of it?
I don't think that's, well, one thing is that there's nothing in the rules that, of the new practice direction which in any way abrogates the current rules of privilege. They remain in full force. It will be for individual firms to decide what their policy is, much as they would keep, no doubt, the notes that they have made in meetings with witnesses. If they decide to make a recording, whether visual or audio, I'm sure it will just be filed electronically and kept. But there's certainly, it's not, there's no sort of subtext here for an attack on privilege or for the judge to have the power to call upon the production of the videotape of the first proof. That all remains privileged.
And there is another question for you, John, which is on the new witness rules, how does one deal with documents which the witness has looked at in the context of disclosure?
Yeah, I saw that. That was Andrew Clinton's question. That's a good one, and that hasn't, I don't recall that arising in the work of the working party. I think the answer, the practical answer will be that at an early stage, before you start embarking on the disclosure exercise, under the new rules, you probably need to identify who it is that's most likely to be your witnesses. Who do you really need to give a witness statement under the new rules? And if you can possibly avoid using, well, first of all, I would say, get that person proved before you start showing them any documents, because what is clear is that once you prove them and you are going to use them as a witness, then any document that they've looked at themselves or you have shown them has to be recorded in their witness statement. First of all, if you can do it, by the time pleadings are closed, you can see what the issues are. If you can see you've got 2 or 3 potential lead witnesses that you're really going to have to call, my advice would be try and ring fence them, keep them out of the disclosure discussions. Use someone else who's definitely not going to be a witness in the organisation to deal with disclosure. That would be my practical advice.
Thank you, John. Tim, there has been a question in relation to jurisdiction as to where we now are on the prospect of anti-suit proceedings in respect of actions now being brought in EU state courts?
It's a very good question. The answer on its face ought to be that we're back in the good old days before all that fun and games was stopped by Brussels. That anti-suits, in theory at least, whether our EU cousins take any notice of it or not, that we're back in the ancien regime, as it were, and that it's just the same as obtaining anti-suit relief in non-EU countries that we, as one does sort of nowadays. And certainly let's hope that that's the case, because that could get rather fun very quickly.
Thank you. I've got one question here for Simon. I'm not sure we're going to be able to answer this one, Simon, but I'm going to offer you the chance. Does a lawyer's view in an email on a press release about a case he's dealing with for a client attract privilege? Is it part of the continuum?
I think that it will depend on the way in which the lawyer gives what he's asked to comment on and what the nature of his advice is. But I think that to the extent that he is in any way picking up his legal spectacles to look at the draft and advise on it, that it is privileged. If he's being, I suspect if he's being asked whether they should put it in red or green, then that may well not be privileged. He's not being asked to comment on it qua lawyer. But to the extent that he is being asked to look at it qua lawyer, then yes, I would expect that to be privileged.
Thank you. Well, we still have 78 participants, but I don't think there are any other questions. So I'm going to say my thank yous. First of all, thank you to all of you. I think we've had 93 attendees, which I think is a record for our aviation seminars, following on from the record that we had on the last occasion. So we're very glad to see you. You're most welcome. I hope life is good in your home offices, and we hope to see you live as soon as possible. Thank you to John, Mark, Tim, and Simon for demonstrating and giving to us a very clear view of the subjects that they dealt with, and for doing it concisely and effectively within the time that's available to us. So thank you very much to all of you and for the work that you've done. Thank you to Sarah Longdon, who's operating in the background and manages all of these occasions for us. We will send out a summary. If you don't receive it, please get in touch with me or one of us, with Sarah, and we will make sure that you have it, and that if you want to, that you can circulate it. And please also watch out for the announcements for our next seminars. Thank you very much. Good afternoon, and I wish you all well. Thank you.